Uh, Good morning, everyone. I, Advocate Chinkita Agarwal, welcome all the participants on behalf of Lawyers Development Forum team for Sunday Bulletin News and Views. It is my pleasure to introduce today's esteemed speaker, Advocate Sudhakar sir, a guide, a mentor, a distinguished expert in the field of criminal, civil, family, etc. He is teaching law since 1977. He conducts coaching for JMFC exams. Thousands of advocates across him are his students. Hundreds of judges are in the Maharashtra are his past students. He is practicing lawyer since 1977. Today he'll be sharing. His performance suit. We have a question and answers open in the activities. You can post your questions, and in the ends, we will be taking all the questions. Sir, I kindly request you to please start the session. Thank you. Sir, you are not audible.
Good morning to all. Am I audible now?
Yes, sir.
Good morning to all. Very happy to be associated with you this morning. I'm thankful to the organizers and especially backbone of the organizers, Dr. Rajendra Anbhule sir and others, Abhishek, Jagtap and other friends. Friends, today the subject has been assigned to me is pleadings in specific performance suits, concept of pleadings, and its niceties in respect of specific performance suit under the Specific Relief Act. As most of us, we know, friends, the major litigation in the courts is based on Specific Performance Act 1963 as amended in the year 2018. That amendment came into force from 1st October 2018. We'll discuss everything in the course of the dialogue. However, let me speak first about the pleadings. Any civil lawyer, friends, he must be aware and must be fully conversant with pleadings. In respect of pleadings, Order 6, Order 7 and Order 8 of the Code of Civil Procedure 1908 provide for the pleadings and the niceties of the pleadings. Especially, Order 6 of the code relates to pleading generally. Order 7 relates to pleadings and the plaint. Order 8 relates to written statement and niceties regarding or rules regarding written statement. At this juncture, we will not venture to understand all the details of the pleadings because our purpose is little different than to discuss pleadings in the CPC. Nevertheless, at the outset, friends, and especially the newcomers, new entrants in the profession should know, in respect of the Code of Civil Procedure, the provisions are to be found at 4 places. First, the code sections 1 to 58. There are 158 sections in the code. Then there are 51 orders in the code. Then there are schedules. There were previously 5 schedules, of which schedule 2, 3, 4 and 5 now has been deleted, and there is only one, that is the first schedule in the Civil Procedure Code. In this first schedule, again, there are appendix A to H. And in these appendices A to H, for today's purpose, appendix A is relevant. In appendix A to the Civil Procedure Code, in the first schedule, there are various forms in Appendix A1, 2, 3, and 4. In this, there are provisions in respect of various formats of pleadings provided. Various forms of plaints are provided. And especially for today's purpose, you will find in form number 47 and 48 in first schedule in Appendix A, those two forms relate to suits on specific performance. So friends, anybody intending to file a plaint or prepare a suit, then he must read relevant provisions of sections, orders, and then this schedule first and Appendix A, and especially for today's purpose, form numbers 47 and 48. But that is not all. You should know this is not entire CPC. Section 151 up to 158, 51 orders, and first schedule. This is not the total scope of the Civil Procedure Code. Friends, in addition to this, there are state amendments. Different states, they have provided for their own amendments, inserted their own amendments, which are applicable within those states only. So this is third aspect. First sections, then orders, then appendix, that is schedule, and then state amendments. But that is not all. Newcomers should know that in addition to this, there is something more to learn before we start drafting, and that is with reference to civil manual. What is civil manual? I will tell in 2 sentences. As per the provisions in the Civil Procedure Code, there is a delegation power. Power has been delegated by the Parliament to the High Courts. Each High Court is entitled and empowered to make rules for its own governance in civil matters as well as in criminal matters. Accordingly, our High Court, Bombay High Court, has also framed rules which are applicable for civil matters called as Civil Manual and for criminal matters called as Criminal Manual. And hence, if you want to properly draft a plaint or a written statement, then you have to learn these provisions in CPC sections, orders, rules in the orders, then also the forms and the formats in schedule in Appendix A. In addition to that, the state amendments, and in addition to that, the civil manual by the Bombay High Court. Especially for today's purpose, there is a very big volume of civil manual of Bombay High Court. Nevertheless, for today's purpose, friends, there is very little scope. In part 2 of the civil manual, in 8D, small Roman 1, there is a provision made regarding concept of pleadings. So, part 2, 8D1 is the relevant part for today's discussion. This is all. This we have to discuss, friends, for today, for the purpose of introducing ourselves to concept of pleadings. This pleadings as provided. By the way, I will ask you a question before we venture to understand. We always say plaint has been drafted. We never say suit has been drafted. What is difference between plaint and suit? All seniors, if at all, few of them they are hearing, they know it. But for my new entrance colleagues, I will let you know what is difference between plaint and suit. We are not drafting suit, we are drafting plaints. And the difference between the plaint and the suit is that plaint is a piece of paper on which you have typed it, sign it, that you take to the court, you take it to the registry, you take it to the Nazir, and when that is registered in the suit register, then that becomes suit. Plaint, when registered, becomes a suit. That is the nicety newcomers shall keep in mind. So we are speaking about the pleadings in the plaint. When we are speaking about those pleadings in the plaints, then these are the relevant provisions from the Code of Civil Procedure. Now, in Civil Procedure Code, Order 6 relates to general rules. When you start writing plaint, drafting plaint, then you should know what is to be written. And it is said in the first rule itself, Order 6, Rule 1, pleadings means plaint and written statement. So there are two pleadings, that is the plaint and the written statement. And then there are few rules. There are 18 rules in all in Order 6. But we will restrict our scope of discussion as to few of them, to highlight important of them, which will be relevant in our subsequent discussion regarding specific performance act and the specific performance drafting. First rule provides, or the few rules they provide, it says your pleading should be precise, concise. No doubt elaboration is necessary, but unnecessary elaboration, unnecessary particulars and details are not necessary. It should be precise and concise in the first instance. Secondly, it says, plead the facts and not the law and evidence. So friends, sometimes a junior lawyer, in over enthusiasm to draft, may surpass this limit provided in Order 6 rules. Otherwise, there is very funny position sometimes arises. You write so many things unnecessarily, then there is a further provision you will find that there is a provision as to striking out of unnecessary pleadings. And therefore, so as not to attract that provision, there is a humiliation of a lawyer. If you are not drafted your plaint properly, and if it is not properly drafted, and then what happens? Other party will object, defendant will object, or the court itself will say that so many things have been unnecessary brought into plaint. Those are unnecessary pleadings. Let us strike it off. So friends, write all, but don't write excess. Otherwise, there will be striking out of pleadings also. So in addition to this, when such pleadings are to be provided, it says, plead the facts and not the law and evidence. So friends, if at all you want to file a plaint based on agreement to sell, say for instance in our today's subject of Specific Relief Act of 1963, and therefore you are to called upon by the client, sir, please draft for me a plaint for agreement to sell and the sale deed based on that. The defendant has executed an agreement to sell in favor of your client plaintiff, and you have served a notice, and now you want to file a plaint and subsequently a suit. Then, in such a suit, in such a plaint, you shall draft in such a manner, plead the facts. Golden rule is plead the facts and don't plead the law and evidence. Therefore, what is fact? Not stated in CPC. That is to be found where? In the Indian Evidence Act of 1872 and now the Saksh Adhiniyam of 2023. And therefore, anything, state of thing or relation of thing which can be pursued by senses. Therefore, you have to write only facts of the case. And when you write facts of the case, you write all the particulars, and mind well, in few cases, no particulars are to be stated, and in few cases, further particulars are to be stated. Say, for instance, if you base your plaint or your case on fraud, then immediately rules comes into operation. It provides that particulars of fraud must be given. What is fraud is to be found in the Indian Contract Act. And it is provided in Order 6 that whenever you want to plead fraud, then particulars of fraud must be pleaded. Especially in case of a fraud, there are two basic aspects theoretically. One, either there is suggestio falsi or suppressio veri. Suggestio falsi means a false thing has been suggested, and suppressio veri means there is concealment of a material fact. And therefore, in commission of a fraud, particulars must be given. Otherwise, what happens, friends? If you go to the courts as a junior lawyer and sit beside your senior or generally in the court, when cross-examination is going on and when questions are put, then judge says next. Question is put and judge says ask the next question. That is humiliating to the lawyer. It means you have not properly studied it and you have not properly understood CPC as well as the Evidence Act. Means, friends, when we want judgment, there must be argument. And when there is argument, there must be evidence. And when there is evidence, there must be pleading. Therefore, entire structure of your case is constructed and is built upon the foundation and the basis of the pleadings. Once pleadings are disturbed and distorted, entire building is likely to collapse. So fate and future of your case is based on the foundation as is to be found in the notice and in the plaint. Therefore, when you draft the notice as well as the plaint, you shall be cautious as to few aspects we shall be discussing, especially with reference to suits in respect of specific performance. So that is the relevant, that is the importance of pleadings in respect of plaints. Whenever such suit is to be drafted or plaint is to be drafted, while drafting it, if you are producing any document, then friends, the relevance of document should be stated in the plaint. It should be narrated in the plaint. What you write in the plaint is said as averments. Those are said as averments in law. So your averments, what is stated in the plaint, must be such a relevant aspect. And this relevant aspect is to be found in respect of the provisions in the Civil Procedure Code before we come to the Specific Relief Act and its relevance therein. So this is the aspect which you shall keep in mind, back of your mind, before you start drafting a notice as well as drafting a plaint. Rather, I will suggest to you, I will advise you that before drafting of a plaint, you should properly learn how to draft a notice. Friends, I have seen in my 47 years of practice and teaching that few cases, very important cases, have been lost only for few sentences, few words in the notice. When matter goes to the apex court, matter goes to the High Court or to the Supreme Court, then what is read first is your notice. And if something has been admitted, something has been stated, then that becomes binding on the shoulders of your client till the apex court. And therefore, as a junior lawyer, in the beginning, we should be very cautious as to drafting of the notices and drafting of the plaint. Whenever you go for such a drafting of the notices and drafting of the plaints, friends, then you should remember, so as to draft it, or so as to provide for such a pleading, we should know that provisions are to be found in Order 6, Order 7, and Order 8. Based on this, we have to use this discussion which we had just now as to our today's subject. This was just a background. This was not our today's main subject. But junior lawyers should know that this is the paraphernalia. These are the parameters which you are going to use in our further discussion while drafting a plaint or the return statement in respect of suits based on specific performance. For this purpose, question arises, what is specific performance? What is performance? And all this comes from contract. Friends, we know the Indian Contract Act of 1870. In respect of this Indian Contract Act, contract is entered into. We know that proposal and acceptance and consideration, and then we know how contract is performed. Therefore, contracts are performed in single sentence for the purpose of performance. When contract stands performed, parties are satisfied and there is no more contract. Contract stands discharged by performance. Contract comes to an end in the first modest desired way, and that is performance. Two parties come together, they enter into a contract, and then performance is there. Contract stands discharged by the process of satisfaction. However, sometimes, say for instance, the defendant has agreed to sell his land to plaintiff, and accordingly both are honest. He has given the sale deed, he has paid the money, entire transaction is over. He gets his name entered into 71 extract, he gets his money, deposits in the bank, both are happy. Contract stand discharged by the process called as performance. So you need not go to the courts. However, you go to the courts when you are required to go to the court when either party is dishonest, either party causes breach of the contract. If either party causes breach of the contract, then contract is not performed, and therefore there will be breach of the contract. There will be breach of the contract, and by breach of contract, now the aggrieved party has a right to go to the court. Here we come to today's subject. When you go to the court, what do you claim? First, you may claim damages. You may claim compensation. Where it is provided, if either party to the contract causes breach of the contract, then the aggrieved party has a right to approach and to go to the courts is stated in Section 73, Section 74, and Section 75 of the Indian Contract Act. To what extent you are entitled to claim compensation, you are entitled to claim damages, but not penalty. Anything less than penalty or up to penalty, you are entitled to claim damages or compensation as stated in Section 73, 74, and 75 of the Contract Act. That is all. If contract is broken, you can go to the court, file a suit for money in the form of compensation and damages, and you are happy with this. Contract consequence comes to an end. However, sometimes party may not be interested in money only. Party will require, I don't want money, I want performance in specie. And that is called as specific performance. When there is a contract for sale of land, sale of a house, and party agrees to sell house or sell land to the to your client, and then thereafter says, no, now I will not sell and I will not give the sale deed of the property. There are two ways. You may file a suit simply for compensation and damages in terms of money. He has broken contract, I want money from him, that is all. But if at all you are interested not in money, not in compensation, not in damages, but you are interested in that property in specie, you want that house itself, you want that land itself, and you go to the court and say, I don't want money, I don't want compensation, I want that property itself, then that is called as specific performance. And that specific performance comes from the Latin term in specie. Specie means in particular, that thing only. I don't want money, its transformed form. I want that original form itself, agreed thing itself, agreed performance itself. Then that is called as specific performance. This specific performance has been stated in Specific Relief Act. If it is money, if it is compensation, go to Contract Act 73, 74, 75, and that's all. However, if you want not money, but you want specific performance along with money, then you have to go to the Specific Relief Act of 1963. And in respect of the Specific Relief Act of 1963, there are various forms of specific relief. One of the aspects, as the organizers have informed me, is as to first to tell you what are the various specific performance reliefs which we are entitled under the Specific Relief Act. Friends, for this purpose, I will let you know in the beginning itself what is specific performance. In a jurist book, very interesting illustration has been given. And that interesting illustration is, there is an engagement of a boy, and he gets engaged, and there is a marriage proposed between himself and his fiancée. And then there is engagement program, and in the engagement program, a ring has been presented. And then they exchange the rings. Then another neighbor of that boy is very jealous of him. He comes and forcibly takes away his ring and puts it in his finger. They go to the court, and then court will ask him, what money you want? Take this money, take this lakh rupees and go away. He says, sir, that its monetary form is not relevant. I'm not interested in money. I'm interested in that very ring because my emotions are attached to that ring. Then that is said to be specific restitution. I want that ring itself. Then that is specific restitution. It is not in Contract Act, but that is provided in our today's Specific Relief Act. Therefore, there is restoration of possession, restoration of that very thing, or when you are interested to claim specific performance of the contract by way of sale deed of that contract or otherwise, then that is the relief provided in this act. So, in this act, there are various reliefs to be found, especially provided in Section 5 to Section 8, Section 9 to Section 25, Section 26, Section 27 to Section 30, and then Section 31 to Section 33, then Section 34, and then Section 35 to Section 41. My junior colleagues, this most wanted, most desired, most relevant law which civil practitioner needs every day is the smallest law I have seen in my civil practice. Because, friends, in this law, there are together 42 sections only. Of the 42 sections, last section has been now deleted, and there are 41 sections only, 41, of which 1 to 4 are preliminary sections. 5 to 8 are relating to possession sections, restoration of possession, recovery of possession. And then section 9 to 25 relate to specific performance. Section 26 relates to rectification of instruments. Sections 27, 28, 29 and 30 relates to rescission of contracts, termination of contract. And then Section 31, 32 and 33, they relate to cancellation of instrument or documents. Cancellation of instrument or document. And Section 34 and 35 of this Act, they relate to declaration, suit for declaration, and consequence of declaration in Section 35. And then the provisions in Part 3, that is as to Chapter 7 and Chapter 8, as to Section 35 to Section 41, they relate to injunctions, prohibitory injunctions, perpetual injunctions, and to some extent interim injunctions concept. This is all. This is all we have to study in this Specific Relief Act. Therefore, there are such various specific reliefs made available in this law. Recovery of possession in Section 5 to 8. Specific performance in Section 5 to Section 25. Section 9 to Section 25. Section 26 relates to rectification, and then there is rescission, and then there is cancellation, then there is declaration, and then lastly injunctions. This is the scope of today's subject. Out of this, friends, when we have discussed all this, we have to understand first the relationship between Contract Act and today's subject. Now, this relationship, the nature of today's subject, nature of the relief we are going to claim under this law is to be found in Section 3 and Section 4 of this Act. You have to therefore, in the beginning, understand Section 3 and Section 4. Section 3 is what? Section 3 is very interesting section. In civil law, if you want to practice in this civil practice, then 3 acts you must always have together. You must always carry 3 books. These 3 books are CPC, the Specific Relief, 1963, and then Contract Act. You'll ask me a question, sir, where from this entire scope starts? In CPC? No. In Specific Relief Act? No. It starts from contract. So, of this trio, of this trinity, the first important law is contract. Because Specific Relief Act will come into operation only when there is a contract. If there is no contract, Specific Relief Act and CPC will not come into operation. And therefore, the basic law which we shall understand and study is in respect of the Indian Contract Act. And therefore, the formation of contract, the consequences of contract, parties to the contract, their competency, adequacy of the consideration, everything comes from Contract Act. Then question arises for our consideration, what is the relationship between these 2 laws? How the Indian Contract Act and how the today's subject of Specific Relief Act, they are interrelated. And it is said they are not inconsistent, but today's subject, Specific Relief Act, is complementary to, is supplementary to the Indian Contract Act. Indian Contract Act is not supplementary to Specific Relief Act. Indian Contract is not complementary to Specific Relief Act. Specific Relief Act is complementary and supplementary to the Indian Contract Act, because in respect of Indian Contract Act, and especially in respect of section 1 to 75 of Indian Contract Act, there are various provisions to be found as to general principles regarding contract. Contract is entered into as per those provisions only. The competency of the parties and all other legal requirements are to be found in Indian Contract Act. And then comes today's subject in section 3. Section 3 is the connecting link between the 2 laws. This is the connection between the 2 laws. What is connection? What is the relationship between the 2? And then section 3 says, except as otherwise provided in this act, herein, except as provided herein, nothing in this act shall be deemed to deprive a person of any right available to him, except the specific performance of contract to which he is entitled under any contract. So there are 3 parts of this section to understand. First part is except as otherwise provided herein, means unless in this act something is stated, something is otherwise provided, there shall be no deeming provision, whereby except the provisions of this act, except the relief provided under this act, no other relief under the contract shall be taken away from a person. To simplify this, it means that this act relates only to the reliefs provided in this act and shall have no effect on other provisions in the Indian Contract Act or other reliefs available to a person under Indian Contract Act. This is the consequence. So if you read these 3 parts, there is a comma. If you after the lecture is over, you read section 3. It's a very interesting section that relates to these 2 laws. Again, I will say in one sentence. First, read Indian Contract Act. Then read Specific Relief Act. And don't read CPC just now, because CPC is a procedural law, and this procedural law is for enforcement of those rights which a party, which your plaintiff acquires under Contract Act and Specific Relief Act. Those are substantive laws. Those 2 substantive laws are to be enforced with the good offices of the Civil Procedure Code. And therefore, Civil Procedure Code will provide at a later stage the consequence. However, Section 3 is the connecting link. And Section 3 says that this act, Specific Relief Act, relates to those reliefs only. And there is no deeming provision Nothing is construed to take away rights under the contract. This is the relationship between the two. And then, before we come to the next consequence herein, that is provided, especially in respect of the provision is to be found in section 4. What is section 4? Section 4 is that what are the rights created by specific relief act, and it is stated in section 4. It is for enforcement of individual civil right and not merely penal rights. So there is a qualifying clause in section 4. This qualifying clause in section 4 provides that this act is responsible for individual rights. These are not social rights. Public rights are not enforced. My individual rights are enforced. And that too, individual civil rights are enforced. And therefore, this law relates to civil rights to be enforced of the individuals. This is the relationship between the two. And then comes the consequence stated in respect of section 5 to section 8. I will not take much details of it because there is a very lengthy portion then. But it is my duty to make mention in section 5 to section 8. Friends, whenever there is a recovery of possession, then the relevant provisions are to be found in the Code of Civil Procedure. And in respect of the Code of the Civil Procedure, the consequence is to be found especially in respect of title-based suits. If there's a title-based suit, you know limitation is based, usually 3 years, and sometimes the various provisions in the Limitation Act. However, in this act, there is another additional further provision for recovery of possession has been, as I have said, in specie performance. And therefore, if any person has been dispossessed, maybe his owner or not, if any person has been dispossessed without his consent, then he may institute a suit under this act, not under CPC. Section 6 and section 8 of this law provides for such institution of suits. Only limitation is provided. Section 6 relates to recovery of possession of immovable property, and section 8 relates to recovery of possession of movable property. Only 3 requirements, juniors to remember. First, when you have been dispossessed by the defendant, then you have to file this suit within 6 months' time of the dispossession. If you have been dispossessed, that Limitation Act of 1963 will not be applicable. The limitation for such suit has been mentioned in section 6 itself, and that is 6 months' time. So within 6 months' time from the date of the dispossession, you have to institute such a suit. Secondly, such a suit cannot be instituted against the government. It can be instituted against individual party only. And then once this suit has been dismissed or has been decided against you, then there is no provision made as to appeal. No appeal, not against government, and within 6 months from the date of the dispossession, you have to institute such a suit. Friends, usually it is said that suits are not filed, suits are instituted, because it is said sometimes applications are made, appeals are preferred, and suits are instituted. These are the peculiar words. And therefore, such a suit is to be instituted as per section 6 within. Such suits are to be instituted within 6 months period. Hereafter, you will find, irrespective whether your suit has been dismissed, it is decided against you. This is an exception provided to section 11 of the Civil Procedure Code. Most of you, the juniors, should know section 11 of the Code of Civil Procedure Code of 1908 provides for doctrine of res judicata. And in respect of doctrine of res judicata, in respect of the same subject matter, you cannot file another suit. To that rule, now here is an exception. And even though your suit has been dismissed under section 6, irrespective of that, you can take and you can file another suit based on title. You can file a suit based on title with reference to this first part. Now, we'll go to the next discussion. That all was available before 2018 amendment. I will not go to the amendment in detail, but 2018, there was an amendment introduced by the Parliament which became effective from 1st October 2018. And there has been, friends, the provisions made in amendment whereby entire nature of this act has been changed. Entire nature of this relief has been changed. Junior lawyers, to understand in today's lecture, if you understand that much also, I feel that today's lectures, my object has been satisfied. Earlier, what we people studied, what we people taught, and what we people practice was one sentence, that relief under specific relief act, relief under specific relief act is equitable relief. Relief under specific relief act being equitable relief is discretionary relief. Judge has discretion. Maybe there is no arbitrary discretion. Nevertheless, this discretion is judicious discretion that is fortified by the judicious consequences. Nevertheless, it has been discretionary relief. And that was so especially because of two provisions in the earlier civil procedure code. That is now no more in the code. That is no more in the Act, Section 10 and in addition to that, Section 20. Section 10 then provided that specific performance may be granted by the court in its discretion. So in Section 10, it was one sentence section. And there was a word may. Court may grant a specific performance. Now, friends, by 2018 amendment, word may has been deleted and that has been substituted by the word shall. Now it is mandatory for the court to decree performance suit. Specific performance suit is to be decreed and it is no more a discretionary relief. Earlier, what happened? This may and discretion was the consequence for a very simple reason. Even though all the factors, all the facts were proved in the suit, decree should follow, but not in this act. In all other laws, if the ingredients are proved, then decree must be followed. There must be decree passed. However, in this act, irrespective whether all elements have been proved, irrespective of that, the judgment could not follow or decree was not to be prepared accordingly for a very simple reason. Judge, even though plaintiff has proved everything, was not bound to pass the judgment in favor of the plaintiff because it was discretion. It was comparative hardship. Now that element of comparative hardship has been thrown out by the amendment of 2018, and now it is made mandatory, binding for the court. If the plaintiff succeeds in proving his claim, his plaint, and his suit, then court shall grant specific relief. Therefore, that discretion has been taken away. That century-old law, because it is century-old, because original specific relief act that was of 1877, that was amended in the year 1963 and further amended in the year 2018. Therefore, this law is in force for about 150 years. Now, that law, which did exist in India for 150 years, has been changed in one stroke by two provisions in Section 10 and Section 20 of this Act. In Section 10, may has been deleted and substituted by the word shall. And therefore, now it is binding for the court to pass the decree if the plaintiff proves all the requirements as pleaded in his plaint. He proves all the facts in the plaint, answers the issue according to the issues have been answered. The court is now bound to pass the judgment in his favor and decree the suit. Discretion is taken away. May has been substituted by shall. And then comes the further part. Further part in Section 20. There is a very historic change made. You shall take into consideration. Earlier, when we practiced, we studied, and when it was being taught before 2018, heading of the Section 20 was discretion of the court. The heading of the section itself was discretion of the court. Now that has been taken away. That discretion of court in grant of specific performance has been taken away, and now that is substituted by substituted performance. Now it is no more discretion to the court. As it is the law of contract, as it is any civil law, likewise this is also a civil law. And therefore, that nicety of the specific performance suits as to discretion with reference to section 10 and section 20 has been taken away. It is as good as any civil suit now. And therefore, in respect of section 20, as discretion has been taken away, now there is further provision made by section 20, that is substituted performance. And for drafting a plan, we should know what is the substituted performance. And this substituted performance, as provided, especially in section 20, provides if any person has entered into any contract and the defendant has broken the contract, he has committed a breach of the contract, then plaintiff has such a choice. He will give him a notice. Notice shall be of 30 days. He will ask the defendant to cure the defect or to provide for the consequence that to perform his part. If he fails within 1 month's time to commence and answer it, then the plaintiff may of his own commence the work. The person may commence his work, the rightful party may commence his work and complete it. And when he completes it, then he will file a suit for recovery of damages against the defendant. Then comes the plaint and then comes the suit against him. This is the change made. You will ask me a question. So what is exactly this change made? And why you say it to be historic? Friends, was very simple. I'll give one illustration. Say, for instance, your client entered into contract with other person for construction of his bungalow or a building. And then that defendant or the contractor, he has left the work incomplete. What are the consequences for your client to do? Earlier, before section 20, the consequence was very simple. He has to file a suit for a specific performance and claim and ask him that you construct it. And then by the time he constructs, by the time that your suit is decided, where was your client? He was on the road, he was on the street, and he was looking to the court, and he was coming to your office for years together. First the case will be decided, then defendant will be directed, then defendant will construct, and then I will go to reside therein. This was 10 years in the Indian court system. Now, by virtue of section 20, this has been changed. By virtue of section 20, this has been changed by way of substituted performance. If the defendant now, that defendant, your client's contractor, fails to construct and complete the work, what is the remedy left? Remedy left for your client is that he says, now I will invoke section 20. He'll serve a notice. We'll ask that contractor, that gentleman, within 30 days time, you have to start the construction. You undertake the construction. And if the defendant fails to commence it again, to resume the work, then your client will be entitled to employ the agencies, or you can do it yourself or through other contractor, complete it, go and reside in it, and then to file a suit for recovery of money. First, you are outside of the house for 10 years. Now you are in the house, you are staying in the house, you are rented it, and then you have filed a suit against the defendant for recovery of money. So this is the difference between these two aspects. Now, based on this aspect, let us go to the further higher discussion. Now, all provisions have been made. There is a contract, there is a breach of contract, it is a suit for a specific performance. You are drafting suit for a specific performance. Say, for instance, it is a suit for agreement to sale of an agricultural land, and now you are drafting a plan. What things you shall consider? First, see the question whether there is oral contract, oral agreement, or whether that is a written agreement. Question will be, if there is written agreement, it is a registered agreement, then your job becomes easy. Because in respect of written and registered agreement, then you will be writing the contents in the written or the registered agreement, and then you will be saying that defendant has failed and refused to perform his part under the contract. Then all details you will provide as provided in Order 6 read with Order 7 of the Civil Procedure Code. Order 6 and Order 7 will help you out to frame your plaint and to jot down the points for writing in your plaint. That is one aspect. If it is written, no, it is a written contract, it is a registered contract. But If it is not a written contract, then issue will arise before you, your lawyer, whether in respect of oral agreement also there can be specific performance or not. If the owner of the land has agreed to sell his land orally, whether specific performance can be claimed, and answer is of course yes. Whether it is oral or written, specific performance can be claimed, because it is the contract of which specific performance can be claimed. So it makes no difference for the law, written or oral, but it makes difference in respect of your drafting of a plaint, your preparation of a plaint, because in respect of a written registered document, you'll be referring to the contents 1, 2, 3, 4. And accordingly, evidence will come before the court. In respect of written registered document, there is very less evidence is required. But in case of oral, your pleading should be very meticulous. There shall be detailed pleading required. There must be chain of pleadings required, because in respect of oral agreement, in respect of oral contract, there must be availability of the evidence at the end. And to have the availability of the evidence at the end, there shall be pleadings. Unless you plead, evidence is not allowed by the court. And therefore, there shall be elementary introductory consequence in your plaint. Pleading should be provided in respect of contents of the oral contract or the oral agreement in the pleading itself. There is, mind well, when you are basing and writing your plaint based on oral agreement theory, there is heavy burden cast on the shoulders of the plaintiff to plead and to prove it. You have to give more evidence, you have to give cogent evidence in this behalf. And therefore, first aspect you have to consider as to pleadings in respect of oral as well as written agreement accordingly. Second very interesting query arises, and that is in respect of suits based on specific performance. What is relevant is plaintiff, he must be ready and willing to perform his part. I have seen few plaints wherein it is simply said that yes, plaintiff was ready and willing to perform his part. This is not sufficient. To say only that my client or the plaintiff was and is ready and willing to perform his part itself is not sufficient. Ready and willing from what to what? When from? He shall be ready. Up to what time he shall be ready? He shall be ready during course of the trial. He shall be ready during the contract. He shall be ready up to what? And has been held by the Supreme Court of India. It has been held by our apex court that plaintiff shall be ready and willing to perform his part under the contract from the very date of entering into agreement till decree, not the judgment. It has been observed by the Supreme Court of India that readiness and willingness is not merely up to the judgment, it shall be till execution of the decree. And therefore, friends, there shall be readiness and willingness. But difficulty arises. How to draft readiness and willingness? Only simply saying, I was ready and I am willing will not do. And again, for your information, junior colleagues, whether this readiness and willingness are the same, why the parliament has bothered to write two words, readiness and willingness? Are they same? They carry the same meaning? No. They are not having the similar meaning. They are having different meanings. Parliament has intentionally used these two phrases and terms, readiness and willingness. Ready is different and willing is different. Let us see the nicety, because based on this, while drafting your plaint, while writing your notice, you have to write what I am saying now. In respect of readiness and willingness, what you have to write, friends, is simply this. Readiness relates to your ability to perform, and willingness is your intention. One is ability, other is intention. Ability means, say for instance, you have entered into agreement with someone and you are ready to buy it. And then the defendant has refused to sell it to you and refused to give the sell it to you. And then you file a suit for specific performance. You say, I'm ready from the beginning. Ready means you come and I'll get a sell deed. But this word ready relates to availability of your funds, availability of your money, and your ability to perform your part under the contract. Hence, whenever such suit and plaint is to be drafted, what you shall state? Yes, plaintiff has entered into such kind of agreement, and from the very beginning, he has money available with him. He has money in the bank, but not always necessary that there should be money in the bank. It is sufficient if you have made arrangement for this purpose. You may raise the loan, you may contact the friends, and you make arrangements regarding raising of the funds. But it shall be stated in the plaint that either I had money from the beginning, or today I have also the money, or some friends have assured money money to me, or I have made arrangements with the bank for the purpose of raising of the funds for my performance. This should be stated in the plaint. That is the word readiness. So readiness is your ability to perform your contract, and this should be pleaded. Not pleaded, your suit is liable to be dismissed because of Order 6, Rule 3. Friends, mind well, very small thing sometimes becomes very dangerous in lawyers' practice. You just refer to Order 6, Rule 3. Order 6, Rule 3 says that pleading must be in the form prescribed, in the forms in the schedule. You must read it. Rule 3 says that your pleading should be strictly in accordance with the forms prescribed in first schedule, Appendix A. And especially for today's purpose, form number 47 and form number 48 of the code. In those forms, it is specifically stated, plaintiff is and was ready and willing to perform his part. So this should be pleaded. In those plaints, if it is not pleaded, then in such a suit, evidence will not be allowed, and then subsequently suit may be dismissed. So this should be meticulously pleaded, and then we come to readiness has been done. Readiness is availability of funds. Readiness is your ability. However, second part relates to willingness. Willingness means you have got money. You have got money in the bank. You have got FD in the bank. But you are not giving to the defendant. You are not giving to that person who has entered into agreement with you. Then what is the utility and use thereof? And therefore, friends, in such a case, when money is to be given, your performance is to be done, and you are not undertaking your performance in this case, then that there is no willingness in your part. Readiness is ability. Willingness is your desire to perform your part under the contract. This should be specifically stated in the plaint. If not provided in the plaint, then very well, friends, your suit is liable to be dismissed on this count itself. Then, once this readiness and willingness is, yes, properly pleaded, everything has been done, and then comes a very peculiar aspect, especially in the litigation arising in the rural areas, especially in agricultural lands.